Good morning friends, I am Ashish Agarwal from Team NGOenabler and today we shall discuss another very important update. This time not from the Income Tax Department or the FCRA Department but from the Ministry of Corporate Affairs. On 9th July 2025, MCA notified amendments to the company's CSR Policy Rules 2014, bringing in a new version of e-form CSR-1. This form is critical because every entity undertaking CSR activities must be registered through CSR-1. So in this video, we will understand what has changed, what new details are required, and what it means for the companies and the implementing agencies. So let's have a look at the key amendments. The first and foremost, replacement of CSR-1 form. The old CSR-1 has been substituted with a new detailed format which is now applicable with effect from 14th July 2025. Then the scope of the entity details have been widened, which means the new CSR-1 requires entities to clearly specify whether they are a Section 8 company, registered public trust or a charitable society, and have income tax recognition either under Section 1023C or Section 12A and approval under Section 80G of the Income Tax Act. And also whether such entities are set up by the central or state government or under any act of the parliament or state legislature, as they too can register themselves for CSR. If the entity is set up by a company or a group of companies, details of such company including CIN, the corporate identification number, must also be furnished. If not, the entity must have a track record of at least 3 years in undertaking similar activities. Then some information has been made mandatory, which means the registration number or the corporate identification number, the date of incorporation, address, PAN of the organization and email ID for the OTP verification, the one-time password verification, is now mandatory. Along with that, the authorized representative details including their DIN or the PAN, the designation and the email ID is also made mandatory. Regarding the attachments and the declarations, the copy of registration certificate and the PAN are the compulsory attachments. The organization can also attach Section 12A and 80G registration certificates. A board resolution authorizing signatory must also be enclosed. And depending on the type of the entity, the form must be digitally signed by either the director or the trustee or the chairperson, CEO or secretary, whatever you call it. At last, a professional certification is also required. The form now requires the certificate by a practicing professional chartered accountant or the cost accountant or company secretary, and the professional must declare that the records were properly verified from the original or certified documents. All the attachments are complete and legible. Otherwise, the professionals will be held liable under Section 448 and 449 of the Companies Act 2013 for any false statement or misrepresentation. So let's understand the impact of such changes which is made in CSR rules. In the context of the companies, they can now fund only those implementing agencies which are registered under new CSR-1 format. So before releasing CSR funds after 14 July 2025, check whether your implementing partner has properly taken the CSR registration on the MCA portal with the valid documents. For the NGOs or implementing agencies, you must recheck your registration under Section 80G, 12A or 1023C and ensure all approvals are valid and updated. Without CSR-1 registration, you will not be eligible to receive CSR funds. And at last, for the professionals like CAs, CS and CMAs, they must be very cautious while certifying CSR-1. Any negligence can invite penalties due to strict certification liability. Now comes the most important question in this regard, for which multiple calls and queries have already come. Whether the organizations already registered for CSR and having valid CSR certificate need to re-register themselves, or rather say renew their certificate by filing the new form CSR-1. Though, looking at the MCA notification, it might feel that clearly the existing CSR-1 has been substituted with a completely new form effective 14 July 2025, and nothing has been explicitly mentioned that already registered organizations will be automatically migrated. But in the MCA's instruction kit for e-form CSR-1, under point number 1.2, important checkpoints while filling up the web form, MCA has stated, please ensure that CSR registration number has not already been provided against the PAN of the entity entered in the form, which specifically clarifies that no further filing is necessary if your entity already possesses a unique CSR registration number. So what the existing organizations should do? Verify your number on the MCA portal, ensure you have a valid 12A and ATG registration number, and adhere to the new CSR rules. For those organizations whose 12A and ATG registration has expired after taking CSR registration, technically, in our opinion, their CSR registration shall also stand invalid in the eyes of law. But the catch here is that there is no option open for updating or renewing your CSR registration on the MCA portal yet. Also, no clarification has been specifically issued in this regard by the Ministry of Corporate Affairs. So, the companies need to be very careful while selecting their implementing agencies to ensure they have a valid registration under Section 12A and ATG both. So friends, the CSR-1 amendment of 2025 is a major step by MCA to tighten compliance and ensure that only genuine tax-exempt and transparent entities undertake CSR activities. NGOs and trusts must prepare and update their records immediately. Companies must check the compliances of their partners, and professionals must exercise utmost care. I hope you found this video useful and interesting. We will continue bringing you more of such updates. Don't forget to like, share and subscribe our channel, and follow us on Twitter, Facebook, Instagram and LinkedIn. Thank you.